think we've got this atmosphere a bit heavy. So let's talk about something that our common guru taught us. That's judicial humor. Humor in court is such an underrated asset. I sometimes tell people that, the principle of seduction, hasi to fasi, also applies to arguments in court. If you can make a judge smile, you are more likely to get an order. Murli, has anybody persuaded you that way?
But I've had very interesting cases in the Orissa High Court as a Chief Justice. Okay, let me start with the Delhi High Court. This is about translations. So the lawyer who's very conversant in the language of the place and is arguing before you sometimes is translating, the initial thought in the mind, which is in the local language, and translating from that into English. So I'm sitting on the criminal roster in the Delhi High Court, and the lawyer gets up and says, "My lord, my learned friend's client, my lord, met my client, my lord, outside the court, my lord." And as you know, every
Yes.
my lord has to be every. And he said, "I will see you." So I was, so what? He said, "I will see you." And then the penny dropped. He was translating from Hindi, "Main dekh lunga tumhe." The other man says, "My lord, my friend's client is also not washed in milk, my lord. Doodh se nahi dhula hai." So, even as a judge, sometimes you have to catch yourself and say, okay, this is what he's trying to say. In the Orissa High Court, it did happen. Because, you see, we speak English in a certain way. There's what's called the South Indian accent. I think both of our respective accents are now on display. And there is a pronounced accent in other places, so you're used to listening in a certain way to certain words. I would ask a sentence of a lawyer, and the lawyer would look at me, as if I've spoken some Greek Latin. When I turned to my colleague and said, "Can you ask him the same question?" the answer would be pat there. So there can be instances of getting lost in translation. And the last thing about judicial humor, I think our senior has so many such instances. This was a case.
We are supposed to write a book together.
So this was a case where he was appearing for the state of Maharashtra. The judge was a very sharp, quick-witted judge. And he had been convinced by the lawyer for the petitioner who was facing sentence, which was a sentence in the range of, up to 7 years. And this was coming up for the second time before the court. So since the judge knew the case of the petitioner, he was hurrying up the petitioner and saying, "No, I've gone through it fully now, and really there is nothing on merits." And like any good opponent lawyer, my senior was sitting down and not trying to interfere at all, just watching what is happening between the court and the petitioner's lawyer. The petitioner's lawyer, knowing that he was not getting past the judge, said, "My lord, please permit me to add a word so that my lords can shorten the sentence." At which point, my senior gets up and says, "I need not remind my friend. If he adds a word, it can only lengthen the sentence."
We're nearing the end, but we can go on and on. I'd like to throw the session open to questions from the audience. And please keep your sentences short. Don't add to them.
So, sir had just mentioned the name of Chandrachud Senior, to which I recalled the Shah Bano case.
Yes.
And so what had happened, that after the judgment was passed, the government passed the Muslim Women's Act of 1986 to essentially nullify the judgment. So does that, do such repercussions hold in mind when you are passing a judgment, sir, that, it might create a lot of backlash?
No, actually, interestingly, that had a second innings, the Daniel Latifi case. That act was challenged in Daniel Latifi. Very interesting how that act was upheld, saying it does not actually undo what Shah Banu did. Anyway, that's a different academic discussion that we can have. Judges should not have. Like, I was constantly asked, were you under pressure as a High Court judge? Did anyone try to pressurize you? And my answer then, and my answer remains, you feel the pressure only when you acknowledge it. So this, when you take an oath without fear or favor, affection or ill will, this fear that you're talking about, fear of the repercussions of your judgment, altering your judgment, is what you're supposed to abjure, what you're supposed to overcome. So I think we have seen good examples of judges doing what they have to do, irrespective of the consequences, because that was the right thing to do. We have great examples of H.R. Khanna, who's being talked about so often in our judicial circles.
Sir, during the Delhi Riots case,
Yes.
you made a late night judgment.
Correct.
And there are arguments that you upsetted the corridors of power, so you did not make it to the Supreme Court bench. What is your views on this, sir?
See, I don't know what is it that upset, because I think any other judge should have done the same thing and would have. I expect every other colleague of mine in the Delhi High Court would have to react in the same way. I don't think anybody else should have and could have acted differently. So what is it that upset the government? I am as clueless as you are on what upset them, if at all they were upset. So I only have this to say that it does not matter, because I think we've got the answer even from this room that many people did feel that that was the right thing to do at that point in time. And in fact, it was. I mean, from what I've heard people come back later and tell me, I think many lives were saved with that intervention by the court on that date.
It's written somewhere that even if you save one life, it is as if you have saved humanity. So Murali, I'm very proud of you for that.
Thank you. Thank you.
Hello, sir. This is a question that has always crossed my mind. Do you think the judiciary, the police can be assisted, replaced by the artificial intelligence, the computers? Do you need an emotional, human point of view?
Yeah.
Or is it just facts and figures, tuck,
I think
and
are.
you give the
So
judgment?
this is what is called rhetoric, right? Rhetoric means the answer is already there in the question. So you already answered the question. All these are only tools, right? They are tools to help you function better as a judge. Okay. You can't substitute your decision, which has a variety of factors. There is this emotional quotient as well. And it's not about black and white. It's not about just assembling facts, applying law, and saying this is the decision. It cannot be. It should not be. I've said this in other platforms, and I can share this with you. Initially, when you're a judge and you look at facts, they say something to you, right? I've had judges who've never sat in a criminal roster. They've never practiced criminal law, but they're now supposed to sit on the criminal roster and decide. So every time a bail application is placed and the prosecutor naturally asks you to look into the first information report, if you're not exposed to criminal law practice, every case will seem a horrendous case. You can't grant bail in any case at all. So one of the very senior judges who, of course, reached the Supreme Court and retired had this to share, that when he sat on the criminal roster in that high court, in the first 3 days, and bail applications in a high court will be in hundreds, 100, 200 bail applications. He said, I couldn't bring myself to grant bail even in one case. So at the criminal bar, the bar of lawyers was very upset. So he himself realized this and talked to the Chief Justice and said, can you shift me to a different roster? So because there is so much to be done in every case that you have to keep the human factor in mind. Like a woman, look, the hardest cases are these. A woman throwing her 2 children and wanting to jump after the 2 children into a well, right? Because of utter poverty, not having food to eat. And the children die and she survives. And it's a clear case of 302, right? Now, as a judge, it really, it's heart-wrenching to sentence that kind of a person, sentence them to imprisonment. So you will have many judgments where the judges say that this is a really hard case, which is calls for remission by the executive and all of that. You'll have that. Like you have between first-time offenders, second-time offenders. So for judges, when you come back, when you deal with some problems in the first instance, and then you come back to it, let's say after 10 years, you have a different reaction to it because now it's the zoom out effect. From zoom in, you go zoom out. You see things in a larger perspective. You're able to place things in a larger perspective, and therefore you're able to take an informed decision. So your own life experience comes into this decision-making process, and no artificial intelligence, no computer can substitute that. So that's the answer.
Yeah, as a judge, any judgment where you had, a moral turpitude, personally you didn't like giving that judgment, but you still had to deliver that moment.
No, there have been several criminal cases where you felt that, either the investigation was very bad or the investigation was biased. So when you have to give verdicts on those kind of cases, it makes you uncomfortable. And you wish that more hard work had gone into it. And you try and correct it as best as you can. So these are difficult moments when you know that, they've botched up the case. Like, there are many innocent tribal populations in Orissa where there is one eyewitness and there's no effective cross-examination of that eyewitness. And you feel that if that cross-examination had been conducted properly, the result would be completely different. I had this experience of correcting those errors when a wrong case number was indicated in the investigation report in the MLC.
Yes.
And that was overlooked by the trial court till it got discovered only in the High Court later. So there have been many errors like this that happened during investigation where you feel that your verdict would have been different had the investigation happened properly.
My name is Dr. Girish Mood. I'm a cardiologist. I live in Bangalore, but I work in the US. And while you were answering all the questions, I was just imagining the role of a doctor who faces the same thing and the two professionals which face this. Now, as a medical professional, we have malpractice, which keeps the checks and balance. My question to you is, what do you think is the role of something like that, which is going to check the performance of the judiciary system, given the scenarios which has been happening around?
Yeah, actually you brought up a very important point which we wanted to discuss but didn't, which is the role of the lawyer. We have a very weak disciplinary system for the bar. In fact, people are fed up in trying to give a complaint against the lawyer, knowing it will go before his peers in the bar council and nothing will come of it. In fact, we have the weakest of the systems. Even Medical Council of India was pretty bad. And now they have a new act. I hope it's any better. I don't know. We'll have to test it out. But our professional bodies do not have the kind of discipline and checks like the bodies abroad have. As a doctor practicing in the US, and you can correct me, I think you have to renew your license. You have to pass through a whole set of tests. Correct? And even if you pass the license test, let's say in California, it may not hold good for Montana or for New York or for Florida, every state. Likewise in the bar there, you can pass the bar exam in, let's say, Florida. But when you come to New York, you'll have to take the New York bar exam. So there is a check on, your ability to continue to perform competently as a professional. You have no such check in India, which is one great failing. In the lawyers' bodies, whether it's the Bar Council of India or the Bar Council of the States, there has to be some, complete introspection and relooking at malpractices by lawyers because they're also outside the net of the Consumer Protection Act. And the only body you can turn to are these disciplinary bodies, the Bar Council of India and Bar Council of the States. And I must say it's been very disappointing to see their performance. So much needs to be done. I think that needs to be debated about. Every time we debate about the judiciary, we don't debate about the lawyers and lawyer bodies. We have to, because I keep saying this, the bar is the nursery from where all judges come. A lawyer who lacks integrity can't become a judge of complete integrity. Impossible. A lawyer who is very fearful, who lacks independence, can't become a fearless and independent judge. You reap what you sow. So if you don't have strong lawyers, independent lawyers, competent lawyers, don't expect the judiciary suddenly to have all of the brilliant judges that you want. or independent judges that you want. So we need to discuss about the bar much more without fear. Without fear.
Last question from the lady, and then we hand it over to the executive.
I think continuing on the thread of looking inward, one of the things that I have felt is judiciary's independence is compromised because it puts itself in that position. And what I mean by this is if judiciary itself can be more transparent in its functioning, be it the way the collegium decisions are taken, what are the parameters based on which a judge is selected. We did go into some discussion, but we still don't know in terms of ABCDE, what are the qualities, what are the metrics that determine who a judge is, or how the budgetary allocation is made and how money is spent within the judiciary, or how cases are allocated. Because there is no transparency on these issues, I think the executive has that ability to compromise on independence and overpower the judiciary on multiple fronts. You have, of course, been one of the exceptions in this front by releasing annual reports of Odisha High Court, which was a very detailed one, and congratulations on that. Several other states are following the trend, which is a great positive. But it is not something that comes as a matter of policy within the judiciary to be more transparent about its dealings.
I think he's got your question, and we are.
I think she's given all the answers.
But what is your take on it? I would love to hear.
I am somebody for greater transparency, but it must be an informed, consensual transparency. We should have a debate on what we want to be transparent. Like a system of appointments, like somebody writes an article saying, just like how judges in the US are appointed, we should have the same system here. I don't think we are mature enough for that. We are not mature enough for that kind of grilling by the entire Congress of a judge, of the Senate by the judge, of the judge by the Senate. We are not, I think, mature enough for that. But I do agree with you, we need greater transparency. There's no doubt at all. We need greater transparency on the criteria that we're looking in the appointments. What are we looking for when we appoint a judge to the, because you know those criteria, at least in the subordinate, levels of the entry level in the judicial service and the mid level in the judicial service. So I don't see why we can't have criteria of whom we are selecting for, and of course of the other administrative work that we do. I think if the Orissa High Court annual report can be a good template for this, and there's also a PIL portal of the Orissa High Court, which I would urge all of you to look at, where we are trying to make that also more transparent.
So in the interest of transparency, let me tell you, and I don't think Murli knows that, but Murli possibly became a judge as a result of a conversation between me and Rohington Nariman, as he then was. The then Chief Justice of the High Court had asked Mr. Fali Nariman for recommendations. He asked Rohington, and Rohington just asked me as one of the members of the bar. And at the last minute, Murli's name popped up. So Murli, whatever you have done or suffered in the last 17 years, I own up to my share of it. That's my transparency.
No, but I've not suffered at all. I just want to tell the audience here, I've enjoyed every minute of being a judge. There have been moments of great satisfaction, and not the least the NAS Foundation judgment. And I must share with all of you that when Justice Shah and I delivered the judgment, we could see people break down in court. So it was a very emotional moment and I think that triggered a change in this country, which we are seeing now play out. So there have been many such moments as a judge when you have tremendous satisfaction of, having been a judge. When you bring closure to a case that's been pending for years and years, or you've delivered what you think is justice to a person who's been denied justice. So no suffering as a judge at all, only satisfaction.
And on that note, ladies and gentlemen, we leave you. We hope you've had an insight into how judicial processes work. Thank you very much. Thank you, Bangalore.